Imagine waking up tomorrow to find that you no longer have control over the company you built. The board of directors is suspended, your management powers are stripped, and a court-appointed interim resolution professional has taken over your business. This is not a hypothetical scenario. This is exactly what happens the moment a Section 7 petition under the Insolvency and Bankruptcy Code (IBC) is admitted by the NCLT. Defending against a Section 7 petition filed by a bank or financial institution is not just a standard legal dispute, it is a fundamental struggle for corporate survival. The IBC operates on a creditor in control model with a truncated timeline, giving you a mere 14 days to present a robust defense. Today, we are breaking down the ultimate legal playbook to shield your company from aggressive lenders and prevent premature corporate death. To beat an insolvency petition, you need to understand the twin test. The Supreme Court has clarified that the NCLT's inquiry is incredibly narrow. They are not looking at general business grievances or complex equity issues. They are only looking for two things: the existence of a financial debt and the occurrence of a default. If the tribunal finds both, they are generally obligated to admit the petition. Therefore, your entire legal strategy must focus on completely destabilizing one of these two pillars. You must scrutinize whether the debt is legally due and payable. For instance, if the creditor breached their own reciprocal obligations under the contract, like stopping the final tranche of a construction loan that prevented you from finishing a project, you can argue that the default was not voluntary and the debt is not legally due. The NCLT admission process is a strict tick box exercise, which means technical and procedural lapses by the financial creditor can provide an incredibly effective defense. If the bank's petition has missing or expired board authorizations, or if there are major discrepancies between their petition and the default dates logged in the information utility, you have grounds to derail the proceedings. A massive emerging defense involves unstamped loan documents. If the core financial agreement or debenture trust deed is unstamped or insufficiently stamped, it is technically inadmissible in evidence. You can successfully argue that the tribunal cannot admit an insolvency petition based on a legally unenforceable void document. What happens if the debt and default are both undeniably true, but your company is fundamentally healthy and just facing a temporary liquidity crunch? You can invoke judicial discretion. While the courts have narrowed this exception recently, the law still states the NCLT may admit a petition, implying they have the discretion to say no. Your legal team must immediately present overwhelming evidence of your company's solvency. This means showing active project contracts, employee payroll records, or massive pending arbitral awards against government entities that exceed the debt amount. You can argue that pushing a viable, going concern into liquidation defeats the very purpose of the IBC. Defending a Section 7 petition is a high-stakes chess game. You cannot wait for the dust to settle. You must engage legal counsel immediately upon receiving a notice to draft a comprehensive counter-affidavit. You must weave together technical procedural objections, statutory bars of limitation, and a deep dive into the commercial substance of your financial transactions. If your company is facing the threat of NCLT admission, do not leave your corporate survival to chance. Contact our legal defense team today to build your strategy.